Have you ever wondered what to trademark, when to trademark, and what the differences between trademarks and copyrights are? My name is Zara Watson Young, and I'm the co-founder of Watson Young Law, and I'm here with our co-founder, Sean Young, and we represent female founders all over the world, and we help them protect their intellectual property, specifically their trademarks and copyrights. So today we're going to be first talking about what to trademark.
Yeah, super excited to get into these topics because it's common questions that our clients have. And I think there's a bit of mystery about what you should trademark. So the first foundational trademark for most businesses is going to be the literal word mark. So the words of your trademark. And the key is to make sure that you have a distinct trademark. You can't trademark things like best hot dog stand in the world, right? Because that's what the law calls descriptive, right? You want to have something very unique that describes your goods or services. So when I think about something like that, I think about Google, right? What is a Google? Before Google, no one really knew what that was. It certainly didn't mean an internet search engine that everyone's going to use across the globe. But now that's synonymous with Google. So Google is a very unique name, and the spelling of Google is trademark, Google. It's fully trademarked. So that's the first foundational trademark most businesses have that makes them distinct, and it'll protect the sound, the appearance, the connotation, and then the trade channels that they're in.
Yes. So you can trademark your business name, you can trademark your logo, you can trademark your slogan. So any catchphrases that you commonly use and that you want to be known for, you can trademark that. And then going back to your logo, so there are different types of logos. There are primary logos, submarks.
Composite logos.
Correct. So there are different types of logos. So let's say you work with a website designer. Your designer will typically give you a suite of logos. So you can actually trademark each of those, right? The United States Patent and Trademark Office, they consider each variation of a logo to be trademarkable. Right? I think I made up a word, trademarkable.
It works. We would trademark that.
But yes, so you can trademark your different logos. And then a common question that we get asked is, over time, if you make any changes to your logo, do you have to trademark that? And the answer is yes. And the reason for that is because the USPTO, or the government, the trademark office, they have to make sure that no one else is using any variation of that logo. So each logo will require its own application.
Right. And I think logos are very, very powerful, especially in the consumer goods space. The goods space, typically you want to have the logo on your good, on your packaging, because it creates a psychological effect between yourself, your brand, your business, and the consumer. And so that connection is so important. I think about McDonald's, the word mark, and then McDonald's, those golden arches. It's synonymous with fast food everywhere in the world, the golden arches. And so as you're building your intellectual property portfolio, and that's what it is, you're building a suite of logos or slogans or word marks, you want to be strategic in how you do it, and you want to make sure that over time, every variation is protected under the law. It's very important. And when you're doing a search, one logo could go through and not have any issues, but that variation might conflict with another mark. And so it's so important to make sure that you do the proper search and you go in. It's not just like, oh, I have a logo, so my new logo will be fine. No, each logo will have its own examining attorney review the actual application to make sure that it doesn't conflict with anything else that's out there. So very important to note that logos are extremely powerful, and you want to make sure that you're doing the right thing by protecting each variation, and understand that just because you have one doesn't mean you'll have automatic rights to the other. You want to make sure and treat each one as its own intellectual property asset.
Yes, absolutely. And something else I want to touch on in terms of what you can trademark. So we often get the question, can I trademark my LLC name? And
All the time.
Am I protected? I have an LLC. Do I even need a trademark? So to quickly answer that, yes, you do need a trademark, because an LLC is completely different, or having a legal entity is completely different than owning a trademark. Your LLC is there to protect you from liability. It protects your personal assets. So if you have a home, a car, your personal bank accounts, all of that is protected under your LLC, including your trademark. So your trademark is considered an asset under that LLC. And what I mean by that is, when we are filing your trademark application, for example, we would never file under your legal name. We would always file under your legal entity or your LLC. So It's very important to understand the difference between having an LLC and a trademark. The two are very different. And then, yes, you can trademark your LLC name because it is the name that we'd be protecting. But I just want to clarify that having an LLC is separate from owning a trademark. You essentially need both.
Yeah, I think trademarks is it's so powerful because when you have a trademark by the USPTO, it's protecting that name in all 50 states. When you file your LLC, you're filing your LLC in one state, right? Whether it's Georgia or New York. And so it's not giving you, just by virtue of you filing in the state, it's not giving you protection nationwide. It's just literally for two reasons. Like you said, liability protection to make sure that your corporation's assets and your personal assets are separate, and your tax purposes. The IRS has to get its cut, and so they want to make sure that they have a designated EIN to that LLC, so that any revenue that you create from the business, they can have a means of tracking and taxing it. But it doesn't protect you. It doesn't offer you protection in the marketplace, and so it's a very common question that we get from our clients. Well, I have an LLC. Well, just because you have ABC Corporation, there may be an ABC Corporation in another state. And so it doesn't protect you in all 50 states. Trademark law does that. So very important question. Absolutely.
Yeah. So let's move on to when you can trademark. So a lot of times, or a lot of business owners will come to us and say, oh, I haven't made any money, or I'm not making any money, or you know what, I'll just wait. I'm going to focus our funds somewhere else. And, I don't even know when is the right time to trademark. So our answer is always yesterday. You should have started the trademark process yesterday. The earlier you can start, the better. And the reason is because let's say you are about to launch something, right? You don't want to launch and then start the trademark process because the name could already be taken and you have to rebrand. We had a client, she is a fine jewelry company. She basically spent $40,000 in product packaging and then came to us after having done that and said, you know what, I'm ready to start the trademark process. We began the process, did our comprehensive search, and we discovered that someone else had already actually registered an exact same name. And thankfully, it feels like almost a miracle, we were able to.
Well, we knew the loophole.
We were able to come up with a loophole and basically trademark the name. So saving her that $40,000 that she had spent.
Right. And she came to us a bit distraught. She didn't want to believe what we had told her because can you imagine having to go back and repackage and rebrand? She was one of the very few female founders and jewelry owners in the Diamond District in Manhattan. And so she really had created a name for herself and a brand for herself. And I love that company. I love that client. And fortunately, we were able to successfully register. Of course, we were crossing our T's and dotting our I's and really monitoring that application to make sure that she would get through to the finish line. And fortunately, she did. And it's a cautionary tale. And a lot of our clients believe that they have to have a product in the marketplace already in order to file for a trademark. It's not the truth. There is a way to reserve the name prior to launching so you can get the name cleared. It goes through a similar process. It does take 8 to 12 months, but there's a way to do it, and it's critical. Our clients that do that often have a lot of success because they're thinking like a CEO. And so there's a way to do it that you can reserve the name and then later provide proof that you're using the name to USPTO and locking in that name. And so that's really critical.
Absolutely. So the sooner you can start, the better. So we also want to talk about the difference between trademarks and copyrights because a lot of times business owners are confused, right? You don't know what you don't know. You're creating content. You are creating, maybe different aspects of your business. You're expanding into different product lines, and you don't know how to protect that. So we want to really break down the differences between trademarks and copyrights and also explain, the different types of intellectual property. So there is trademark law, there is copyright law, there's patent law, there's trade secrets. These are all different aspects of intellectual property. And as a business owner, it is really important to really assess your business, do an audit and say, okay, what do I need? What do I need here to protect myself? So let's start with trademark law. So trademark law protects any aspect of your branding. So whether it is your business name, your logo, any slogans that you're putting in the marketplace. So anything dealing with names, that falls under trademark law.
Right. Trademark law protects your slogans, your names, your brand, your word marks. It can even protect sounds. Let's Get Ready to Rumble is a trademark. and it's I think he gets $1 million every time he says that. It's trademarkable. You can trademark product packaging. There's trade dress law. So
Christian Louboutin.
the Christian Louboutin, the red bottoms, that was his
Color.
signature case.
And then there's also the Essie bottle, the nail polish bottle. There's one line that they have, it almost curves. That's trademarked under trade dress.
And copyright is going to protect, we like to say copyright, think content, right? Copyright protects your content. It protects your artistic ideas. It could be sculpture. It could be music. It could be film. So if you're photography, so if you're a content creator, a lot of that is going to fall under your copyright. A lot of your content will fall under copyright. And so it's important also that you're registering your copyright, right? You want to make sure that you're protecting it, you're registering your copyright. If you're an author, it protects your written word. So the law essentially is, as soon as you put pen to paper, you have basic copyright protection if you're writing a book. They call it a tangible medium. However, you also want to make sure that as you're thinking about your trademark strategy, you're thinking about your copyright strategy too. What's going to fall under your branding is this list of content. And so you want to make sure that you're copyright protected as well.
Also, because we are on this podcast, you can protect your podcast name, right, under trademark law. And then in terms of copyright law for podcasts, so maybe you are licensing the content, you can protect it that way through copyright registration. And then also I want to touch on coaches. We work with a lot of coaches. They have different courses. So their course name, that would fall under trademark law. The course content, so the video modules that you're recording, that falls under copyright law. If you're giving your members PDFs or anything downloadable, that would be protected under copyright law. So for our course creators, for our coaches, we want you to understand also where your actual content falls under. So which bucket? It would specifically be copyright law.
Right. And then the next was patents. And so patents really protect inventions. So your invention has to serve some kind of utility, it has to function, to do something. And then it has to be novel. It has to be new. And those are the two key factors with patents. So patents are for inventions. I think about the interplay between copyrights, trademarks, and patents. If you look at the sneaker industry, the Yeezys, right? You have Yeezy, the brand, which Kanye West owned, right? He owned the trademark. However, the underlying technology in the shoe was owned by Adidas. They had patented that. And then they also copyrighted the designs of the shoe. So Adidas owned the design from copyright because, again, when you're drawing the design out and you're making it unique, you'll have that in that 2D function. And then you had the patent, which was the underlying boost technology underneath the shoe. It was novel, it was new, and it served a function. But then the creator, Kanye, owned the Yeezy brand. And so it's interesting, when they actually fell out, they had a falling out, their business relationship ended, they were still able to sell the sneaker, which was the patent and the copyright. However, they were unable to market it and brand it under that trademark. And so the question then was, does anyone really want to buy a Yeezy sneaker that doesn't say Yeezy, right? So there's that dynamic. But that's what patent law covers. I think the most iconic patent is the light bulb, right? You think about that Thomas Edison light bulb. So patents are going to be inventions and even software applications, apps. We're in the age of AI. A lot of that is going to be patented, and some of it falls under copyright as well. So there's an interplay between the three of them. But I think for the most part, for our listeners, patents, when you think patents, you think inventions.
Absolutely. And lastly, trade secrets, actually.
Trade secrets,
and I know that's one of your favorites. So if you want to talk a little bit about that.
Yeah, so trade secrets is interesting because it's not talked about very much, and very few people know about it. There's no way to really register your trade secrets. There's a body of case law that covers trade secrets, and the most iconic case is going to be the Coca-Cola factory. We're here in Atlanta, and Coca-Cola is huge down here. And there was an issue with a worker trying to take their secret recipe, which is a trade secret. I always think about recipes when I think about trade secrets, right?
Too.
Your grandmother's
oh my
recipe.
Gosh,
yeah, it's a secret. It's a family trade secret, right? So someone had tried to take the Coca-Cola trade secret and sell it to Pepsi, and Pepsi reported them. Like, we're not doing that. We're not going there. But that is going to be your trade secret. Do you have a secret recipe? And a lot of times you see it in the employer-employee relationship. You have an employee coming into your company and you have a certain methodology that you use, and then they leave the company and now they're trying to take your trade secrets. And contracts, we do contracts as well, and having the right contracts is critical, whether you're working for a work for hire independent contractor or you have an employee, making sure that anything that falls under their employment, the scope of employment, you're protected or protecting that information, and that information is yours. And that's trade secrets, the fourth element of intellectual property that often gets overlooked.
Yep. And that's it. So if you have any questions about what to trademark, when to trademark, and the differences between trademarks and copyrights and what you need, you can reach out to us at watsonyoung.com and you can schedule a trademark strategy session.
Also, make sure to hit the like button and subscribe.